All rise. First District Court of Appeals now in session. All who have business before this court draw near, give attention, and you shall be heard. May God save these United States, the great state of Florida, and this honorable court.
Please be seated. Good afternoon. We have two cases on the docket scheduled for oral argument this afternoon. Our first case is Joy Mushi versus Florida State Lodge Fraternal Order of Police. Counsel, are you ready to proceed? Yes, sir. You may approach, counsel. We've allocated 15 minutes per side for the oral argument. Would you like to reserve some time for rebuttal?
Yes, 4 minutes, please.
So noted, Madam Clerk. You may continue, counsel.
Thank you. May it please the court, my name is Ashley Richardson, and I represent Ms. Mushi in the appeal currently before you. The issue before the court is a very narrow one about the applicable statute of limitations at issue where an employee files an administrative charge with the Florida Commission on Human Relations and receives no notice from the commission within the 180-day investigation window. Under the Supreme Court's case in the year 2000, the Joshua case, the statute of limitations that should apply is 4 years based on section 95.113F. The issue we have presently is that the 4th District Court of Appeal in its 2023 decision in Alou has reinterpreted that and applied a 1-year statute of limitations where the FCHR takes no action within 180 days. For this case specifically, there's 3 dates that matter. The first is September 22nd, 2021. That's when Ms. Mushi filed her administrative charge. She dual filed it with the EEOC and the FCHR. 180 days later would fall on August 21st, 2021, which was a Saturday, so the following Monday would be August 23rd. On August 25th, the EEOC issued its form notice of right to sue or dismissal and notice of right to sue, the right to sue letter.
In that case, counsel, could the trial court have taken judicial notice of the date the EEOC issued the notice of right to sue? I
think that it did. Because its opinion is based on Alou and notes that the EEOC did, in fact, issue some kind of notice. There was no discussion below as to the actual date of the notice or how that would have changed the outcome of things here. That just wasn't part of the lower court's consideration. Essentially, the trial court here followed the Alou decision and determined that Ms. Mushi's complaint, which was filed on, I don't have the date that the complaint was filed. It was filed more than 1 year after the EEOC issued its notice of right to sue, was untimely. It was March 5th, 2023. The Alou decision was issued on February 15th, 2023. So the issue we have here is that pursuant to 760.11 sub 8, which governs situations in which the FCHR fails to conciliate, that section was amended in 2020. The pre-2020 version is a single paragraph, and that was what the Joshua court analyzed back in 2000 when it issued its opinion. That provision states that in the event that the commission, which is defined by section 760.02 sub 2 as the FCHR and only the FCHR, says that in the event that the commission fails to conciliate or determine whether there's reasonable cause on any complaint under this section within 180 days of the filing of the complaint, an aggrieved person may proceed under subsection 4 as if the commission. Did
the FCHR make a reasonable cause determination in this case on appellant's complaint or notify the appellant of its failure to do so?
It did not. There was no notice received from the FCHR whatsoever inside or outside of 180 days. So under this pre-2020 version of subsection 8, it's just that single paragraph. The Supreme Court determined that the use of the word may in subsection 8 was permissive, meaning that an employee could proceed as if they had received a reasonable cause determination, but they weren't required to. And to liberally interpret the statute as a whole, as it's required by the language of 760 itself, the statutory mechanism, the 4-year statute of limitations, should apply. In 2020, which is sort of the issue here, in 2020 the legislature amended subsection 8 and added an A, B, and a C. The language of 8 plus A is the original section 8. None of that has changed, including the use of the word may. They did add a B and a C. Subsection B says, the commission, once again defined as the FCHR, shall promptly notify the aggrieved person of the failure to conciliate or determine whether there is reasonable cause. And then it adds requirements of what that notice must state. The notice shall provide the options available to the aggrieved person under subsection 4 and inform the aggrieved person that he or she must file a civil action within 1 year after the date the commission certifies that the notice was mailed. None of subsection B applies here. We're still under subsection A, which is the Joshua holding. Because here, the commission didn't issue a notice, and in fact, neither commission issued anything within 180 days, which makes this case a little different than several of the others we currently have pending before this court. Regardless, the FCHR wasn't the one that issued any notice, and the notice that was issued by the EEOC does not contain any information about Ms. Mushi's rights under the Florida Civil Rights Act or that subsection 4. So the notice doesn't comply with subsection B. The FCHR took no action within 180 days. It just doesn't apply. It's the same with subsection C, which just states that a civil action brought by an aggrieved person under this section must be commenced within a year. None of that is applicable here. So we're still under subsection A, which is the original version of subsection 8, which is what the Joshua court found the 4-year statute of limitations to apply to. So at this point, there's no reason, ALU just doesn't make any sense. In order for that holding to be applicable here, we have to read additional definitions into the definitions provision of Chapter 760, and we have to ignore these new provisions of subsection 8B that has all of these requirements as to what the notice might contain. So the ALU holding says that the notice from the EEOC should qualify as notice from the FCHR. There's no mechanism in 760 that would find that to be an accurate reading of the definition section. And quite frankly, the legislature saw fit to amend 760 in 2020 and add these additional provisions and essentially put an additional burden on the FCHR or requirement that they must notify an aggrieved employee that they failed to take any action within 180 days. But they didn't amend the definition section to include the EEOC or any notice that the EEOC might issue as triggering this 1-year statute of limitations.
Had the commission provided some notice at any point, then your position is that would have triggered the 1 year under the new provisions?
If they had issued it within 180 days, then yes, that would apply. Because the initial opening paragraph of the new amended subsection 8 still includes the within 180 days. So if this had fallen on day 181, we would still be under the Joshua provision where the FCHR failed to take any action within that 180-day window. So that, I don't believe, has changed regardless of the amendment to the statute. So we have the ALU holding requiring us to add a definition that the legislature didn't include into the definition section and also ignore subsection B of, well, I guess subsection 8B. Because the only way for the EEOC notice to trigger this 1-year statute of limitations is to ignore that the FCHR is the one that needs to issue it, and then it needs to include very specific guidelines for the employee as to what statute of limitations applies. Because if you look at the generic, I say generic, but it's the form notice that the EEOC checks the box on and sends to the aggrieved employee, it is only related to their federal claims. They have 90 days to bring those federal claims in whatever court they happen to choose to pursue them in, should they choose to pursue them. There's no reference to any state statute of limitations, the state law claims, or anything that would in any way alert an employee as to what deadline would be applicable.
Do you think we should reach all of this, or should this be resolved earlier with regard to whether the trial court should consider the documents on a motion to dismiss?
Oh, that was one of our concerns below, was that the trial court should not have considered all of those because the notice of right to sue is not sort of a foundational document to the complaint. For example, like let's say there was a contract issue, and the Summerlin case that this court essentially looked at the exact same issue as to whether or not on a motion to dismiss it was relevant to discuss or actually attach the notice of right to sue to the complaint, and it found that it wasn't. It wasn't a foundational document necessary to bringing the complaint. So I think that I would argue that it's better served for a summary judgment motion, but the core issue is still the same regardless what statute.
Assume for the sake of argument that we agree with you that the trial court abused its discretion in denying your motion to strike the documents in question. Then what's your relief on appeal?
I'm sorry, what's my relief going to be?
Assume for the sake of argument that we agree with you that the trial court erred in denying your motion to strike the documents in question, then what is your relief on appeal?
We wouldn't need any. I think without the documents, we allege in the complaint that we satisfied all conditions precedent and exhausted all administrative remedies. So absent this additional looking to the documents outside the four corners of the complaint, there's nothing else really to argue. And
But then again, would we reach the merits of the issue?
not of this particular issue, no. That would, if we just go back to the motion to strike, we're just ignoring all of the sort of foundational stuff, and I suppose we would see you after the summary judgment motion was filed, because this is, that seems to be the state at which this issue is often decided. This is the first time it's come up in a dismissal. And like I said, based on Summerlin, the court did abuse its discretion, but I think the primary issue is really just which statute of limitations should apply. And it would be, I guess, our request that issue be
Again,
resolved.
regarding the 4-year statute of limitations.
Yes, the 4-year statute of
Okay.
limitations.
Assuming the 4-year statute of limitations of section 95.113F, I believe, applies, when did the limitations period begin to run in this case?
In this case, I believe it's when it's 4 years from the time that the claim would be essentially perfected, for lack of a better word. So 180 days would be the starting of that clock. But even if we were to go back to when she filed her complaint, she still filed it timely within the 4 years.
And when was the case perfected in this case?
In this one, our argument is that would have been February, let's see, so August 25th would have been the date. Sorry, I'm really bad at math. It would have been August 21st of 2025. So
And
we're
what
not
is
there
the-
yet.
What is the significance of that date?
That would be the 4 years from the expiration of the 180-day window. So we've given the administrative agency the opportunity to do what it is they're going to do. They don't do it, that starts our clock. Just like it would if they had issued a notice, and the 1 year would start at the time that they took some kind of action. Essentially, the period here would begin at the time where we have concluded that their action is available. I believe I'm into my rebuttal time now, so if there are no additional questions, I'm gonna.
Thank you, counsel.
Good afternoon. May it please the court. Paul Darajati on behalf of the Fraternal Order of Police.
So what do the documents show?
I'm sorry, sir?
What do the documents show? The documents that appellant wanted stricken?
The documents show exactly when the right to sue letter was received and when it was filed.
By the commission, right?
By the commission, yes, sir. Yes, sir.
So
Yes, Your
the
Honor.
appellant actually received notice.
Correct. Yes, Your Honor.
So the argument here in this court is we should pretend that the appellant did not receive notice.
No, I would submit to the court that the fundamental question before you is what actually is notice. If you follow the line of argument of the appellant, they're arguing that the EEOC can never be noticed.
I understand that, but tell me what those documents show.
The EEOC right to sue letter showed when the appellant filed her charge against employer and when she received her right to sue notice
From the commission.
from the commission. Yes, Your Honor.
So if those documents apply, which the trial court held that they do, there's no debate on appeal, right? She received notice from the commission.
Yes, Your Honor. That would be our position, that she received
The
notice from
state
the commission. I apologize.
The state commission.
She did not receive notice from the FCHR. I mean,
Ever.
we can agree on that.
All right.
The notice came from the EEOC. And the question that we're presenting to the court is what exactly is proper notice under the statute? And we would argue to the court that the notice, based upon the Alu case, which found its support in Woodham from the Supreme Court, that the EEOC right to sue letter can serve as notice under the statute.
Going back to the motion to strike, counsel,
Yes, Your Honor.
does the face of the complaint conclusively establish the expiration of the 1-year statute of limitations to serve as a proper basis for a motion to dismiss. And please explain.
Yes, sir. When we looked at the complaint, we saw that there was a time issue. And what we argued below is that based upon, in response to the Stratton Properties case, or excuse me, the Summerlin case, based upon the purpose of filing the right to sue letter, including that with the motion to dismiss in that case, it was distinguishable. In Summerlin, the defendant filed his right to sue letter for the purpose of pointing out that it was an incorrect basis for filing for a cause of action. Whereas under our position is that we're simply pointing out the procedural defect. The procedural defect comes from the law itself. The plaintiff has 180 days from the point they receive their right to sue letter.
Yes, Counsel, but here wasn't the date of issuance of the EEOC notice critical to the motion to dismiss, yet absent from the four corners of the complaint?
We would submit, yes, sir. Yes, we would argue it is critical because statutorily, the plaintiff would not have the ability to file her cause of action, her claim, which was filed on March 5th, 2023, probably about 500 days after she filed her original charge against employer. Under that circumstances, statutorily, she wouldn't be allowed to proceed under 760.11 sub 4. Our position was critical, procedurally, and we're not attaching something as the defendant did in Summerlin, debating whether the substance of the charge merited the right to sue letter.
Why didn't the appellee raise this issue in a properly supported motion for summary judgment as opposed to a motion to dismiss?
Our position was that under these circumstances, the defendant, where we can see from the face of the complaint that there was an affirmative defense, that we shouldn't have to proceed through the discovery process where it was vital to the plaintiff.
So can we address the argument that appellant is primarily relying on, it seems to me, which is the EEOC letter can't qualify as the trigger notice?
Yes,
That
sir.
only a right to sue letter from the state commission can trigger the one-year statute. Tell us why that's not accurate and why it's not contradictory to Joshua.
Yes, Your Honor. Under ALU, the Fourth DCA made the decision that a
Yeah,
right to sue letter.
Not under ALU, under the statute.
Under the statute. The statute requires that the commission issue some type of a notice, but the statute also allows a party to dual file. What they're essentially arguing is that under the law, the commission, or the EEOC, I should say, can investigate a charge against employer, but cannot issue notice on a charge against employer, which the Fourth DCA, when they examined that, it didn't conform to
I
this.
really don't want to talk about another DCA decision.
Yes, sir.
Let's talk about the statute and Joshua, which is controlling.
Yes, sir.
So I understand ALU might have been controlling below, but it's not necessarily particularly relevant here.
Sure.
Under Joshua and under the statute, tell me why you prevail.
Joshua is distinguishable from what we have here.
Right.
Joshua, the appellant in Joshua never received any notice at all. Whereas the appellant here, she received notice.
But the appellant relies on the plain language of the statute, A, B, and C, that talk about the responsibilities of the state commission to issue a right to sue letter, if you will, for lack of a better term. They didn't do that here, right?
We'd agree they did not do that.
Were they involved in the investigation at all?
It doesn't appear so. It
So-
appears that the plaintiff filed with the EEOC, and the EEOC did the entire investigation and issued the right to sue letter.
So the issue is, should we interpret the statute that talks about you may file within a year under A and apply that restriction, that statute of limitation from filing with a federal entity, EEOC?
Yes, sir.
And tell me again why that, we should agree with you on that.
Because the intent, the legislative intent in drafting this statute was to provide some type of procedural remedy, some type of procedural due process, as the Supreme Court articulated in Joshua. In Joshua, they were very...
The legislature defined commission, though, right, in the statute, and it defines it as the state commission, not the EEOC, right?
Yes, sir. Yes.
So isn't that the best place for us to look for what the legislature intended?
If we were to follow a stringent adherence to the letter of the statute, what we would end up with is a result that a plaintiff who has a charge against employer can determine his own statute of limitations. They could
So
file.
in other words, she knew she had a claim, she filed a claim with the EEOC, that claim was based, I assume, on federal law
Federal and state law.
and state law.
Correct. And if you file, what they're arguing essentially is if you file with the EEOC, you're going to get one statute of limitations, because what they're claiming is that the right to sue letter can never serve as a notice.
So tell us why you think the legislature's intent was to allow the EEOC letter to substitute for the state commission letter. And that's not a hostile question.
No, I think the best way is to look at the statute holistically. Had the legislature not wanted the EEOC to take part in this, they would not have allowed for dual filing when one files with either with the EEOC or with the FCHR. You can dual file, whichever entity has the investigation, does the investigation, and issues a notice, and thereby accomplishing procedural due process, which was the Supreme Court's concern in Joshua, thereby accomplishing procedural due process for the charging party.
And it's interesting, too, this 4-year statute, as I recall, a lot of tort claims now are controlled by a 2-year statute, right?
Yes, sir.
The whole statute of limitations regime was significantly changed by the legislature recently, right?
That is correct, sir.
So for wrongful death, those kind of serious claims, those plaintiffs are limited to 2 years, correct?
Yes, sir. Yes, sir.
But somehow this is going to be a 4-year statute?
If you follow the argument of the appellant, essentially what there are, fundamentally, they're asking this court to create 2 separate regimes as to where you file your claim. If you file your claim with the FCHR, you're going to be limited, assuming
They do the notice.
they do the notice.
Right.
You're going to be limited to 180 days. 1 year
1 year.
after the 180 days are complete. But if you file with the EEOC, it's 4 years.
Did Joshua apply a 4-year statute of limitations?
Yes, sir. It did. It did.
Getting back to the merits, please explain how we can accept your position considering the plain language of the statute, which requires notice by the FCHR and set forth the information that must be included in the notice, none of which were contained in the EEOC's notice to the appellant.
We don't dispute that the appellant did not receive a notice from the FCHR, and that the language of the EEOC's right to sue letter does not have all of the language that 760.11 sub 4 requires. However, if you look at Woodham, the Supreme Court case in Woodham, in that case, what the Supreme Court did was they analyzed how the language of the right to sue letter from the EEOC applies to 760.11 sub 4. And in fact, in that case, they resolved the split in the circuits. The 4th, the 2nd, and I believe the 3rd, the 3rd, all had different opinions as to how to interpret the right to sue letter from the EEOC and apply it to Florida statute 760.11. There was never a question as to whether or not it was notice. It was just a matter of interpreting the notice to apply to Florida statute. So that's why I would submit to you that if this court follows the argument of the appellant, we're going to end up with 2 separate regimes where a charging party, before they even
They would just
file
file with the EEOC from now on, And then they would always guarantee themselves a 4-year statute of
Exactly,
limitations.
Your Honor,
And
exactly.
never have to bother filing the state claim.
And that
And
is,
totally circumvent the legislature's intent of establishing a fairly reasonable statute of limitations on these claims.
exactly, Your Honor, and that's what we're arguing to the
That
court.
seems to be an absurd interpretation of the statute.
And in the Senate notes to, and the House notes to the legislation, they specifically stated that their intent was to close the Joshua loophole
Right,
with
so
the
if we
2020
adopt the
amendments.
appellant's argument, nobody should ever file with the state agency. That would be malpractice. Because why would you do that? And lock yourself into a shorter time frame to file your claim?
Exactly.
Just file with the EEOC and guarantee yourself twice as long to file a complaint as people who have a wrongful death action, all kind of serious tort actions. You can guarantee yourself a 4-year statute.
That's exactly the outcome that we would end up with if we followed the argument of appellant. So,
Would the argument be the same if you have dual filing?
I apologize.
Would the argument be the same if you have dual filing, both FCHR and EEOC?
The argument would be the same, yes, sir. It's, in this case, there was dual filing. The dual filing box was checked. There's no dispute over that. And
In other words, another aspect of it is, the argument by appellant is, the defendants ought to be investigated twice.
if you follow the logic of their argument, you would have to build up some type of regime between the EEOC and the FCHR where once the EEOC finishes their investigation, some mechanism has to get to the FCHR for
Well, they
them
can
to.
start the clock all over again.
It
right?
might start the clock.
But again, there would be no logical reason for anybody to file with the state entity if they can guarantee themselves a 4-year statute by just filing with the EEOC.
That is exactly correct, Your Honor. And none of this is written into statute. None of it's written into statute. It's just, it leads to what I would,
Must the
Argues.
FCHR conduct its own investigation if a charge is filed with FCHR under the statute?
yes, yes. That's my understanding. You file it with FCHR, you check dual filing box, they do their own investigation.
And there was dual filing in this case.
Yes, sir.
Okay.
Yes.
And is there any record that FCHR conducted an investigation of the charge in this case?
I'm out of time, but just to
You may
answer your
answer the
question,
question.
there is no record of that. There's no evidence in the record that the FCHR took any action in this case. Thank you.
Thank you, Counsel.
I'd like to address that last issue. I'm not very tall. I'd like to address that last issue first, the issue of whether or not filing your charge with the EEOC is sort of the gotcha that would allow all plaintiffs to have a 4-year statute of limitations, and that's not an entirely accurate understanding of how the work share process works.
Why not?
Because when a charge is dual filed and it's, let's say it's like in this case, when it's sent to the EEOC sends that charge to the FCHR and it's issued its own case number. So the FCHR is alerted to the existence of that case. They have every ability to put it on their calendar and say, oh, in 180 days, we need to send out a notice that says that we decided not to do anything with this case, or maybe
They've already been told by the EEOC that they've investigated and did not find any cause to initiate litigation.
And
right?
if the EEOC sends that information to the FCHR is free to do with it what it wants. It can take the documents from the EEOC,
So
conduct
let
its.
me ask you to clarify that. So a person can file with the EEOC, solely with the EEOC, correct?
Correct.
Is that what occurred here?
No. You have,
Your client filed with both.
correct.
The FCHR referred it to the EEOC?
I believe that because it was initiated with the EEOC, they would then send the charge, just the basic information, over to the FCHR.
So
but
she filed first with the EEOC?
That's where her charge was.
And how does dual filing agreement work?
So the work share agreement is just that. It is a work share agreement. It allows an employee to bypass sort of a more complicated process of having to file in multiple locations. And it also streamlines the sort of bureaucratic process of investigating these charges. But there is nothing in the work share agreement or the statute that says that that means that the decision will be shared. Because these two statutory schemes, they arise from different sovereigns. We have,
But she received a letter from EEOC, right?
she did receive a letter from the EEOC.
And did not file litigation within a year.
No, because there was no indication that she should. Because under Joshua and the applicable provisions of the new subsection
But in
8,
Joshua, as the appellee notes, there was no notice whatsoever.
technically here, the notice was outside of 180 days
So
as
you're
well.
asking this court to say that the EEOC's letter and the fact that she knew the EEOC declined to initiate litigation should be ignored and the plaintiff rewarded with a 4-year statute of limitations?
I mean, I
Because
think,
that's a reward, right?
I mean,
You're getting a 4-year statute instead of a 1-year.
I don't know that I would call it a reward so much as just the current
That's a
state of
lot
the
more
law.
time to file a claim.
That I'll agree with. It is a considerable
Right.
amount of
So
additional
isn't
time.
it true then that you're better off just filing with the EEOC so to ensure that you're never subjected to the 1-year time limit?
No, because the FCHR it is notified of the case at the time it's dual filed. It
But I mean,
has the
that-
ability
But that
to,
occurred here.
it didn't occur though, that the FCHR took
I
any
know they didn't
action.
get notice. She filed with the EEOC. It was dual filed with the state entity. She gets a letter from the EEOC. She sits on her rights and doesn't file for a year, but now she's entitled to a 4-year statute.
Yes,
That's your argument.
that's the argument, and we would argue that that's the current
Under
state
the
of the law.
statute, must FCHR conduct its own investigation when a complaint is duly filed?
No, it's not required to conduct its own investigation. In fact, neither entity is actually required to do anything, except under the new subsection 8B, in order to trigger that 1-year statute of limitations, the FCHR is required to issue some kind of notice that complies with the requirements of subsection 8B.
Once a complaint is duly filed?
Yes, yes.
And was that
Anytime,
notice issued in this case?
I'm sorry,
And was that notice issued in this case?
it absolutely was not.
And FCHR is required by statute to provide the notice?
Now it is. As of 2020, and according to subsection 8B, the shall is the word that's in that provision. So, all right, thank you.
Thank you, counsel, for your respective oral arguments. Our second case scheduled for oral argument this afternoon is Matthew Paul Beecher versus State of Florida. Counsel, you may approach. Here we will allocate 20 minutes per side for the oral argument. Would you like to reserve some time for rebuttal?
I would like to reserve 4 minutes, please.
So noted, Madam Clerk. You may continue, counsel.
Thank you, Your Honors, and may it please the Court, my name is Luke Newman. I represent the appellant in this matter, Matthew Beecher. This is a Fourth Amendment, a search and seizure case that's before the Court for oral argument this afternoon. And because we have, operating in Florida courts, we have a conformity clause in our state constitution in Article 1, Section 12. Florida courts are required, essentially, to interpret Fourth Amendment issues in conformity with the United States Supreme Court. The United States Supreme Court has spoken on this issue in what is a strikingly similar case called Rodriguez. And in Rodriguez,
Can we talk about the times?
yes, sir.
There was a lot of discussion about that.
Yes, sir.
And I will just note that you're an excellent lawyer, and your briefs are always very good. I think I've written opinions in your favor. I would note that I wouldn't use the word a trial judge cannot imagine their way out of a ruling, just for future reference.
Yes, sir.
But, so, give us the timeframes that are the worst-case scenario for you.
Sure. Yes, sir. And I'll admit that in my briefing in this case, that there was some righteous indignation that
I understand that.
seeped into the briefing. So I'll own that. I think that the state is obviously going to present an argument, and the state's filed a brief as well. I think the state and I agree that the stop occurred at 2:26 or 2:27 in the afternoon.
And he testified that he checked the licenses, he checked the registration, and everything checked out no later than, give us that time that's the worst-case scenario for you.
2:32 p.m.
Nobody disagrees with that.
I don't believe so. There's been, again, I'm hesitant to speak for the state, but there's been this idea that maybe at 2:32 p.m. only maybe the occupants checked out in the vehicle or vice versa. I addressed this, maybe I'll rely on my reply brief a little bit, and I addressed this, that both the occupants and the Honda were, I'm going to say the word clean. That's kind of a colloquial term, but everything checked out.
No warrants, both had licenses.
That's correct. In fact, I don't want to confuse the issue, because then I agree that there might have been some righteous indignation in my briefing in this case, but then my brief also went up further and said that there were some other times in the record that made it look like there's something else, some other stuff happened, but I don't even think we need to get to that.
Right.
Because then the earliest possible time that the canine arrived on the scene is at 2:41 p.m.
Right, and that's not in dispute, right?
It's in dispute, I guess, if you read the appellant's brief. The appellant's brief, certainly, I suggest, and I'm arguing to the court, that the court reads this record. There's indications that detention lasted a lot longer than 9 minutes. But
your argument is your worst-case scenario is 9 minutes.
Correct. And then let me take you, Judge Thomas, back to Rodriguez, okay? In Rodriguez, we had a detention on the side of the road in Nebraska or wherever it happened.
I don't think there's any argument that 9 minutes is too long.
Right, and so in Rodriguez, the detention was 7 to 8 minutes.
Right, I mean, from the way I read the applicable law, there's no argument that 9 minutes is permissible.
I agree with that.
That's why I'm trying to hone in on the exact time frames.
And I think, and then I'll acknowledge also that Mr. Beecher's briefs that I wrote go on to show that there are some other factors, there's multiple other factors in this record that show that detention on the side of the road lasts a lot longer than 9 minutes.
Before the dog got there, you mean.
That's absolutely the record. Okay, if we were arguing that there was some imaginary timeline that was larger than 9 minutes, I would be here arguing that detention lasts a lot longer than 9 minutes. But if we can all agree, and I think in my initial brief I wrote about a best case affirmance scenario, right. I said there's 9 minutes. Well, Rodriguez says 7 to 8 is unconstitutional.
Well, even if it's 1, it's still an unconstitutional detention, right?
And the language that gets used, and I think the language comes directly from Rodriguez and some earlier cases that Rodriguez discusses, is there's no longer a concept of de minimis roadside detention, if that makes sense. It used to be a concept, a long time ago, there was a concept that if the dog took, under 15 minutes or so, there was this idea that you're stuck on the side of the road, you're not allowed to leave. But there was this idea that some kind of de minimis detention was constitutionally permissible.
I understand that. I'm going to give you the Allen charge, which is unusual in the appellate courts. But give us the argument, in a sense, your weakest argument, not weakest, but what is the best argument against you on these 9 minutes? I mean, is the state, I've gone through the briefs, obviously, but is there a real factual basis for concluding that it was less than 9 minutes?
I don't see one. And let me make something else clear, because we're talking about 9 minutes, and we're going to wind up beating this to death, I believe. But the 9 minute, the radio call at 2:41, which is 9 minutes after 2:32, is en route. I mean, and then and I know I'll own this. I went overboard maybe in writing about this detention, writing about the stop, writing about the indications and the lack of indication about what might be going on. But the 9 minute radio call is en route. I mean, and so if Rodriguez says.
So what is the state's argument, in your opinion, how it was less than 9 minutes?
I don't think there is a state argument that's less than 9 minutes. And again, I'm reluctant to speak for my colleague from the state, but I think the state argument is there's essentially what I call avoidance arguments. I don't want to be too flippant, but the avoidance argument is, well, there might have been a traffic citation getting written. And I said,
Right, the officer testified he couldn't remember whether he was going to write one or not.
Right.
So let's talk about that.
Sure.
The stop is at 2:26 or 2:27. There's real no dispute about that, right?
Yes, sir. I think we're in agreement on that.
Right.
Yes, sir.
So by 2:32, what is his testimony that would constitute competent substantial evidence?
Right.
Go ahead with that.
He said it was possible that he was writing a traffic citation.
At 2:32.
And then he said it was
He-
equally possible that he had no intention of writing a warning or a citation immediately after that. And it's on the continuation, one page to another of the transcript and the record. And then, but he also, and this is maybe something where oral argument can help us in this appeal specifically, because one thing I wanted to talk to you about is he actually told us. So when I referred to him, the officer, I'll get his rank wrong if I try to remember it, but his name was Cook. And he tells us, right? He told the lower court, something else was going on. I was continuing to investigate. He says that twice. And then he said specifically, he said, I'm not sure specifically what I was doing. So my representation on behalf of Mr. Beecher is that the officer tells us what's going on. He's continuing to investigate. There's something else going on. Well, that's roadside detention. It's unconstitutional. And whether it lasted 7 or 8 minutes or 9, or in Mr. Beecher's position throughout has been significantly longer than that, that it should have been suppressed and a reversal is required.
So again, 2:32, the radio call goes to the K-9 officer? Is that right?
2:32 is when the radio, no, I want to be clear about this. 2:32 is when the radio call goes to the stopping officer, says they're clear,
Right.
that the car,
2:41 is the call to the K-9.
and then I'm going to try and avoid getting into the indignation part of this, but 2:41 is when the K-9 officer says en route. And then his radio says he arrived 5 seconds later. There's a second radio call saying, I'm here, 5 seconds later. Now, he talks about this in
But it doesn't matter to your argument.
not at all.
2:41, 2:42, 7 minutes, 8 minutes, 9 minutes.
I agree, Judge Thomas. I think we're on the same page there. And so, and let me go back to Rodriguez again. Because there's this period of time on the side of the road in which my client's not allowed to leave the scene of the stop, I want to go back to the language of Rodriguez. And Rodriguez says that the reasonableness of the seizure depends on what the police in fact do. And so we might be in a different case. We might have a different case if, for instance, we were in a scenario where the stopping officer said, well, here's a citation I was writing, but when we figured out there was all these bigger fish to fry, if you will, I wound up not issuing it. We might be, let me tell you right now, we would be in a different bowl of gumbo if we had that. We don't have that. We have, I'm continuing to investigate, something else is going on, I'm not sure what I was doing. There's no citation or warning, there's no draft of a citation or warning. So my client's position is at 2:32, the car is clear, the occupants are clear, there's no warrants, everything checks out. There's kind of, if you will, two roads that can happen. And it's either you're allowed to go, you're free to leave at this point, or it's I'm writing a traffic citation. And if we're on the I'm writing a traffic citation road, then where's the traffic? And I'm sure.
Right, if you're writing the citation and that takes 4 to 6 minutes, and he calls an officer and says, bring a dog while I'm writing this citation, that's permissible.
And I would agree with that. And I think what we'd be back to in that scenario, that factual scenario, what we'd be back to is what the police in fact did. Because then we could say.
Well, that's what they say on Rodriguez.
Right, that's the language from Rodriguez. And so I take that language from Rodriguez. I think everybody has professionally seen a Florida traffic citation. It's like half a page. And so if we're there at 9 minutes with the pen filling out a half-page form, the response to that would be, firstly,
well, that's a whole different argument.
Right, then we're in a different, it's where's the.
That'd be an argument that law enforcement was engaged in a subterfuge and they really weren't truly writing a ticket.
They were stalling, it was some kind of bad faith and
that's not what we have here.
Not at all, because we have the testimony, and this goes back to the competent substantial evidence failure. We have this testimony about something else is going on, I'm continuing to investigate.
Remind us again what the trial court found.
Well, the trial court, and maybe this is where I get sideways with you, sir, is the trial court found that that this other officer, the K-9 officer, who arrived with the K-9 and eventually used the K-9 alert to establish probable cause for the search of the Honda, had abandoned this other stop on the other side of Bay County in Springfield and had come to this, the Panama City stop, and then had left and gone back and had basically made a round trip and had gone back to the Springfield stop. And so that was the logic in the order that's on appeal before the
But
court.
what does the order say is the time gap between the time the occupants were cleared and the car cleared and the time when the K-9 officer got there?
I don't think that the final order, and maybe I can address this in my rebuttal time, but I don't think that the order on appeal really has a lot of.
Defines the gap?
I think it acknowledges the gap that we've talked about this afternoon. So I don't think that the order on appeal, my problem, my issue that with the order on appeal was more of the finding about the round trip by the K-9 officer would have explained the radio traffic at the two different arrests that were 7 miles apart, not about, I don't think that the times were.
But the trial court order, as I read it, doesn't say, oh, I find that he was, or correct me if I'm wrong, I find that he may have been writing a ticket, and while he may have been writing a ticket, the K-9 officer was called, and the K-9 officer came while he may or may not have been writing a ticket, so there was no undue detention.
I think that's,
That's the heart of the order?
I think you basically, the outline of it, I think that's a fair characterization of it. Yes, sir. Yes, sir. So I want to I want to argue about something else that got testified to at the lower court hearing. There's this issue about successive radio checks. I know that the state raised this in their answer brief. And I pointed out in the testimony that, Cook testified that he did sometimes successive radio checks. But I want to be very clear about what the record established. The record established that from that 2:32 time that I think is one of maybe the most important time in this timeline.
And the state doesn't dispute that?
I don't believe so. I don't believe so. That the radio is silent. So this idea that I was checking it again, or I was double checking the Honda or the occupants of the Honda during that period of time doesn't hold up on just a basic competent substantial evidence review. And then secondly, Rodriguez, again going back to the language from Rodriguez, says that an officer may conduct unrelated radio checks, but he may not do so in a way that prolongs the stop outside of we're in a reasonable suspicion. And so even if there was affirmative testimony or radio traffic that established, this officer Cook.
And I'm double checking and triple checking. That gets into the subterfuge arena.
Correct. I agree with that. And that I would, so the Rodriguez itself would prohibit an officer from kind of, I don't want to say stall, but prolonging, by saying I need to check for the radio. Now, this court has dealt with Rodriguez at least 3 times since it was issued, right? So we have, is it Wooden? And then we have the Cowart-Darling decision. And most recently, we had a third one. And this court throughout has recognized Rodriguez and recognized its holding. Because there could be, so in that Cowart-Darling decision, there was some discussion about how that case was differentiated because they were in a reasonable suspicion posture there. And also that stop for Mr. Cowart-Darling was prolonged in part because the driver he didn't check out. He didn't have a license on his person.
So here, tell us the significance, if any, and you may argue there's none, to the fact that, was it the passenger who was nervous?
I think it was the driver, was the testimony. The driver was nervous, and I'll rely, going back to that, let me be clear. The state,
because there's no argument that was PC?
Correct, reasonable suspicion for more detention. So the state filed a closing argument after the lower court hearing and never addressed that. And in addition, even if that had been addressed, if we were addressing it here, let's say like for the first time we're addressing it here, that nervousness in conjunction with the traffic stop wouldn't create a reasonable suspicion scenario that would permit additional roadside detention. So with that, I see him in my rebuttal time, and I will yield.
Thank you, Counsel.
May it please the court, Mandy Wabi for the state of Florida. The trial court's factual findings were supported by competent substantial evidence that the dog sniff was completed within the time necessary to address a traffic stop. The record supports the trial court's finding that the officer was conducting traffic stop duties as the dog alerted. So the record supports that at 2:27, the officer initiated the traffic stop, as the officer explained, that would have been the time of him giving the information to dispatch essentially prior to stopping the vehicle. So that, of course, doesn't account for the vehicle having to pull over, stop, and the officer.
So do you dispute that the officer, and I'm not saying you have to, or you don't have to, but do you agree that 2:32 he received information that the registration was valid and no warrants?
So, Your Honor, at 2:32, the officer received, of course, a CAT report stated valid. And the officer actually explained that would have been the time of dispatchers advising him that the vehicle registration was okay. So that's consistent with the officer following the vehicle, running the tag prior to stopping the vehicle. Investigator Cook testified that while following the vehicle, he would have researched the tag. So 2:32 was consistent with him receiving the information, and we don't know if he received it orally.
So at 2:32, he knows that there's no tag violation, no registration problem.
Correct, Your Honor. That would be consistent with him running the tag from that.
Is that also the time and that he knows there's no problem with pending warrants?
Your Honor, as the trial court found from 2:29 to 2:37, the officer continued to do research from there. So 2:37 indicates, of course, the owner's information, and so from the running the tag, and so the officer would have still had to, and it just makes sense, exit his vehicle, obtain the driver's license from the individuals.
Okay, so 2:32, he's informed by dispatch, the registration checks, the tag. So how does the law enforcement agency know that at 2:32? He calls in the tag number, correct?
Oh, Your Honor,
He's got to check the name to the tag, right? He's got to say, okay, the driver is Mr. Smith, his DL number is XYZ123, and they dispatch informs him, yes, that's the registered owners of the car.
that is our understanding, Your Honor. And of course, the times are markers, so their markers are not definitive. But at 2:32, it appears that either and again, we don't know if he received it orally or it took some time for dispatch.
But he's
to relay
told that the
information.
registration is legal.
Correct, that's what the CAT report
And
indicates.
to do that, you have to know the name of the owner, right?
And to do that, he would have to run the tag, so that would be consistent with him following the vehicle and obtaining the information from running the tag from that vehicle. So that would
And
be
these
the
timeframes
owner.
are pretty critical here, so, I mean, if we're gonna rule one way or the other, you know, these stops can be very important. I mean, you might have a suspect, all crimes are serious, but this applies across the board. So what is your argument as to the time of the duration of the stop? From the time that he knew everything he needed to know, that the driver and the passenger had no warrants, the car was properly registered. What is that time, based on the record or as the trial court found? 2:37?
No, Your Honor, no, Your Honor, the times, at 2:37, that did not, as the trial court found, that did not end the traffic stop, because the officer would still had to, again, receive the information, but the officer would still have to receive the information from dispatch, from their driver's license, so.
Okay, that's why, and I don't mean to be a problem here, so to speak, but that's why I'm trying to crystallize these times. At 2:32, the registration is valid. What else is valid at 2:32?
From the record, Your Honor, and again, the times are markers, so we don't know exactly when that information was relayed to him, but the CAT report indicates that the registration or the owner's information as he explained, may have been valid at approximately that time.
At 2:32.
Correct, and
So
that's.
what else did he need to find out?
So the officer would have still need to run the information from the driver's license. So from 2:32, doesn't end the traffic stop, the officer would have had to exit his vehicle.
So what is the time when he finished checking the driver's licenses?
Yes, sir.
We have to know the time.
Understood, Your Honor. And it's
Because maybe
Because-
the duration, maybe the time between the final clearance was 4 minutes before the dog arrived, or 3 minutes.
yeah, sure.
What is your argument as to how much time elapsed, if any? I'll go back over your brief again, but perhaps your argument is the entire time he was investigating them by the time the K-9 officer got there. Is that what the trial court said?
Yes, Your Honor. I mean, that is essentially what the trial court found.
So from 2:27 until 2:41, that entire time, even though he knew at 2:32 the registration was valid, he's investigating.
Yes, Your Honor, and that is supported by the record, because as the trial court found, between 2:29 and 2:37, there was some indication of the research based off, of the officer researching based on the transaction report. So in 2:37, again, the times are markers, but at 2:37, because the officer would have still had to receive the information from dispatch, so 2:37, the officer was still conducting traffic duties. The officer would have had to, as he testified, he would have been writing a citation, because as he explained, when he's asked, did you write a citation, he explains that it's possible, and the trial court found that it was possible he was writing a citation at that time.
But there was
So
no citation.
there was no issued citation, that is correct, Your Honor, but he could have still been drafted, and he considered writing a ticket, so that time frame he would be writing the ticket, drafting the ticket, ensuring its accuracy, at least giving situational awareness to the officer, other officers that he is with. And of course, from there, he would, and all of this, as he explained it takes time. So the officer would have still had to walk back to the occupants of the vehicle, explain to them why they were receiving a ticket, why they may not have been receiving a ticket. And so the trial court found that as the officer, as the K-9 arrived, that he was at the vehicle. The officers, Investigator Cummings, the K-9 explained that Officer Cook was standing beside the car when he arrived. And Officer Cook even testified that he would have been at his vehicle or speaking to the occupants of the vehicle as the K-9 arrived. And so, again, Your Honor, the time stamps, they're markers, but they're not definitive, because.
But counsel, regarding the ticket, didn't Cook testify that it was possible that he was writing a ticket, and it was possible that he was not, and that a lot of things were possible?
Yes, Your Honor, but the trial court, of course, is tasked with weighing the credibility, of course, of the statements and reviewing the record, and his testimony regarding the possibility shows that he was considering writing the ticket. So within that time frame, he could have been writing the ticket, drafting the ticket, ensuring its accuracy. I believe the trial court's findings also include that he did not find it unreasonable that the officers, I believe the traffic stop happened about approximately over a year. But still, the time frame indicates that the officer would have been considering a ticket based on his testimony that it was possible. And, of course, after writing the ticket, as explained, giving situational awareness to the officer he was with, going back to the occupants of the vehicle and explaining to them why they were receiving or why they were not receiving a ticket, and the K-9 officer arrived as he's explaining that to them.
So the trial court's order and your argument is essentially that for 14 minutes, he's either writing a ticket or not writing a ticket. He's got clearance on the registration at 2:32. He's got clearance on no arrest warrants, in your argument, no earlier than 2:37. And so for 4 minutes more, that's just part of him making that decision about giving a ticket.
That is.
Because that's the time frame we're talking about, right? 2:27 to 2:41. Both sides agree with that, right? 227 to 241.
Yes, Your Honor, the stop was initiated at 227 and 241.
232, the registration's valid. Your argument is the warrants and other aspects are being checked on top of the registration, and that's cleared by 237. And so between 237 and 241, he may or may not be writing a ticket, he's talking to them, and then the dog shows up.
That is correct, Your Honor, and time also must be given for the officer to receive the information. So yes, the transaction report provides for
Well, we know that's done by
237.
237.
And yes, Your Honor, and then the officer, of course, maybe that's coming in orally from dispatch, or he still has to review that information. So that is on the transaction report, but the officer, like he explained, still takes time, so he still has to review that information. And as we just discussed, he explained that he was considering writing the ticket, drafting the ticket. So throughout that time from 237 until, as the dog arrived, the officer continued to conduct traffic duties during that time. Your Honor, there's no indication, as the trial court found, that Investigator Cook in any way prolonged the traffic stop or abandoned the purpose of the traffic stop before the dog alerted. Investigator Cook testified that they weren't just sitting there detained and I'm sitting there doing nothing. And for the reasons stated today and in the state's answer brief, we ask that you affirm. Thank you.
Thank you.
Before you sit down, counsel, again, I'm sure this question has been asked for, but what's the state's position as to the time the purpose of the traffic stop was complete?
Yes,
The
Your Honor,
purpose.
so, I'm sorry, Your Honor?
The purpose of the traffic stop.
The purpose of the traffic stop. Based on the record, as the trial court found, the officer arrived at, the canine arrived at approximately 240 per the testimony of Investigator Cook. Investigator Cummings' CAT report provides that at 241, he was at least on scene. And so, of course, the dog walks around the car and alerts at that time. So once the dog alerted, the officer at that point, of course, just decided to, at that point, abandon the traffic ticket at that time. So by at least 2:44, the officer, the individual was Mirandized. So the state position is that, of course, before 2:44, the traffic stop was essentially completed, Your Honor.
Thank you, counsel.
Yes, Your Honor. And we ask that you affirm. Thank you.
Your Honors, I'd like to address just two areas of rebuttal. And I'm going to point, Your Honors, to some pages in the record here. Both, I want to make this very clear, both the occupants and the Honda were valid individually and together at 2:32 p.m. This is addressed on page 241 and 242 of the record, and then it's addressed again, confirmed on cross-examination on page 246. Both the vehicle and the occupants are clear at 2:32. And I want to, when I say that, I want to then refer to something we talked about earlier, which is in this period of time, this disputed period, it was then acknowledged that the radio is silent. So this idea that I'm researching traffic issues, warrants, registration.
So why do we know everything was clear at 2:32?
Because he testified to that. And then there's also in the lower court, had obviously a hearing, contested evidentiary hearing, then the, either the TAR or the CAD, computer-aided dispatch records were put in. So there's some portions of the record where we could get into this kind of conflict between testimony from an individual and objective computer-generated, most of the time we get here, I think, when it comes to video versus live testimony. Here we have CAD, the CAD transmissions. But if there's an argument that butts up against live testimony.
So the CAD transmission at 2:32 is clear?
That's, yes, sir, and it's
And he-
objective.
And he sees that, obviously. He receives that.
Right, yeah.
He
and
doesn't testify, I didn't receive it, or I wasn't looking at that point, I didn't see it till later.
There's no testimony to that effect. And then, so let me go to something else here, because this was addressed just now as well. There's this idea that, this objective computer-generated dispatch report, it's, you know, it's not accurate, or we're trying to fight the timeline here because, and I'm going to read to you what the testimony said about, because there was a dispatcher who was called as a witness in this case. So the defense called in the dispatcher from the county, and what she testified to was if there is a delay, they should normally make a note of that, but normally they try to record the information as here, the court reporter got the word here, I'd suggest it's supposed to be near, as quickly as they can. And that's on page 287 of the record. So the idea that, well, this CAD information was brought in, but it's just an idea, it's just a generalized.
An estimate.
Right, no, this was addressed at the testimony below. So to the extent that the lower court's order, the order on appeal before this court, conflicts with that, Mr. Beecher's position is that there's a competent substantial evidence failure and that this court is required to reverse. And with that, I'll submit Mr. Beecher's case and rely on my briefs for anything further. Thank you.
Thank you, counsel, for your respectful oral arguments this afternoon. This concludes our oral arguments for this afternoon. We are adjourned.
All rise.